Will the U.S. government support Ripple in court? Will the SEC be able to resist Ripple's argument? How much will the XRP court field cost? We will answer these questions in today's video. Attorney Deaton scored a huge victory for LBC token holders in the whole cryptocurrency sector at yesterday's hearing between LBRY and the SECs in the Warren B. SECs in the Warren B. Rudman United States Courthouse in New Hampshire. Deaton, who represented tech journalist Naomi Brockwell as Amici Curia, persuaded the judge that LBC secondary market transactions do not constitute a security. Remember that the SEC tried to sidestep helping LBC by asking for an injunction that applies equally to LBRY, the company's management, and the public? Because of the injunction's wide scope, Brockwell and other LBRY users' attorney Deaton is attempting to have it clarified so that they may engage in secondary market transactions using LBC. According to Crypto Law's creator, he relied on an essay by commercial contract attorney Lewis Cohen that provided a comprehensive overview of all security matters heard in the United States after Howitt. According to Deaton, no U.S. court acknowledged the underlying asset was a security at any point in Cohen's review of security cases. In court, Deaton elaborated on his comments to the judge as follows. The article argues that your ruling seems like you may be suggesting that LBC is security in itself. Please explain yourself. Judge, if you don't mean that, after some back. And fourth, Deaton said the judge stated his disinclination to issue an injunction. He elaborated on the significance of the judge's comments, saying that it was a huge victory since it meant that LBRY users would not be subject to an injunction. Notably, Deaton stated that he had the SECs officially state on the record that secondary market transactions using LBC do not constitute a security. The crypto community applauds the LBRY hearing, which highlights the high stakes at play for every crypto asset Deaton. Deaton's work in the LBRY case, which might be applied in other crypto-related matters such as Ripple v. SEC, has garnered praise from a number of crypto aficionados. Jeremy Hogan, a partner at the legal firm Hogan, praised Deaton on Twitter today for getting the SEC to officially acknowledge that LBC as a token is not a security. The first statement from the LBRY hearing with the SEC. The SEC has said publicly that tokens themselves do not qualify as securities. Mr. Deaton, you've done a great job. Furthermore, Fox Business journalist Eleanor Terrett praised Deaton, noting that no one advocates for the Bitcoin business like Crypto Law's creator. The SEC of attorneys involved in the LBRY lawsuit have admitted over the record, that LBC tokens sold on the secondary market are not securities. Second, nobody advocates more vigorously for the crypto community than Urjana Deaton. If it weren't for him, the SEC would have it so easy. Ripple, the American technology company behind the Ripple blockchain and its native token XRP, has appointed a new president in the person of Monica Long. This development comes up amid the company's heated legal battle with the USE, Securities and Exchange Commission. The appointment was disclosed by Ripple in an official press release on Thursday and further publicized through its Twitter handle today. Starting the year off on a high note, we are excited to share that longtime Rippler and gem Monica Longsfield is now president. Read more about her appointment. Long has been with Ripple for over 9 years, having joined the firm as Director of Communications in September 2013. She entered the scene when the Ripple workforce comprised only 10 employees, according to the press release. Long reportedly championed several initiatives that helped push Ripple forward, working with regulators and getting the trust of global financial institutions. Even in the current challenging crypto environment, Monica has helped guide Ripple to a very unique place of growth and financial strength. She's been an instrumental advisor to me over the years, and I'm grateful to have the opportunity to partner with her even more closely as she embarks on her role as president. Brad Garlinghouse, Ripple's CEO, remarked. Garlinghouse further acknowledged, in a tweet today, that Long has been one of the major catalysts of Ripple's growth over the years, highlighting her brilliance and effectiveness. There's a lot I could say about how singularly impactful Monica Long has been to Ripple's growth. For now, I'll just leave you with, she is brilliant, strategic, and has the ability to pick up and learn skills like no one I've ever seen before. Congrats, Monica! Long and her team were responsible for the launch of the widely utilized Ripple on-demand liquidity (HODL) enterprise crypto network in 2018. HODL, which is touted as Ripple's flagship product, is utilized by global entities and governments to facilitate cross-border settlement. Promoted to general manager in August of 2020, Long spearheaded CPC partnerships with Bhutan and Palau and the launch of the first stage of Ripple's EVM sidechain. The introduction of MFs on Ripple was also overseen by her. Moreover, the San Francisco Business Times has named her one of the most influential women in business. The recent development comes up amid Ripple's long-standing legal battle with the SEC, which has done little to stunt the technology company's growth. Optimism is dominant in the Ripple camp, as several individuals, including CEO Garlinghouse, remain confident of a favorable ruling. Garlinghouse also believes the case is likely to end in the first half of the year. Most recently, investment banker Declarant, a non-party in the litigation, filed a response to Ripple's opposition to their initial request to redact their personal information from a declaration in support of the SEC. This request was made yesterday in a tweet by the blockchain team responsible for hosting digital material. To LBRY, XRP traded on secondary markets does not meet the definition of a security based on the U.S. Securities and Exchange Commission complaint against the company. Sharp users have been quick to echo the demand for action in the wake of the tweet. It follows the judge's recent ruling in Sex UV, LBRY, in which he or she revealed some further details. A status conference was held on November 21 after the court ruled in favor of the SEC on November 7. However, the regulator did not respond to the court's directions to clarify the sale of LBRY credits on the secondary market, LBSU. As a result, LBRY filed a motion to limit the SEC's remedies when it seemed that the SEC was poised to expand the judgment to the secondary markets. At Monday's last hearing, the judge indicated that he would issue an elaboration making clear that his decision did not include secondary markets. This is what Deaton, who argued for a partition between secondary market transactions and the court judgment on behalf of Naomi Brockwell, as a friend of the court, said in public declarations. An eyewitness, Deaton, claims the judge said he had no intention of signing a permanent order to halt the sale of LBC. The pro-XRP attorney further claims that the court had the SEC officially state that LBC did not represent a security based on a document written by commercial contracts attorney, Lewis Cohen. This study examines all US securities cases decided after the Hawaii decision and finds that no court has ever concluded that the asset underlying an investment contract constitutes a security. Several Twitter threads and legal papers, notably Deaton's brief on behalf of Brockwell opposing the SEC's sweeping assertions, have attempted to make this argument. This is good news for XRP investors since it means that the cryptocurrency cannot be classified as a security. One should keep in mind that in December of 2020, the SEC filed a lawsuit against Ripple, claiming that XRP is an unregistered security. It's important to note that the two sides haven't moved an inch in their almost 2-year-long court struggle. However, whether or not they will be sufficient to convince Coinbase and other U.S. crypto exchanges to relist XRP remains to be seen. For perspective, after the SEC's legal action against Ripple, other U.S. crypto exchanges, including Coinbase, decided to delist XRP out of fear of legal action. Note that Coinbase is held up as an exception by many in the XRP community due to a thorough investigation it performed on XRP in 2018 and the resulting conclusion that the asset was not a security. In addition, the cryptocurrency exchange used this research to support its 2019 meeting with the SEC to get clearance to list XRP. This was okayed by the SEC. As of this writing, the cryptocurrency exchange has not responded to the XRP community's concerns. It is more prudent to anticipate that it will hold off until the Ripple case is resolved. In particular, Ripple CEO Brad Garlinghouse has been firm in his belief that a decision would be made by the end of the first half of 2018. According to reports, the briefing phase is through and the judge's decision is the only thing left to be made.